All right, looks like we're live. Hopefully this thing is working. Thanks for joining me. This is episode number 58, I believe it is, of Freedom is Scary. And, this guy named James Otis said back in 1761 that one of the most essential branches of English liberty is the freedom of one's house, because a man's house is his castle. And whilst he is quiet, he is as well guarded as a prince in his castle. Again, James Otis, 1761. So the maxim that a man's house is his castle is older than our republic. It's deeply rooted in our jurisprudence and Anglo-American jurisprudence in general. It protects all levels of society down to, as scholars have observed, even the poorest man living in his cottage. This formed much of the basis of the Fourth Amendment itself. And while these protections, the Fourth Amendment has unfortunately eroded over time in this country, it still, is important. At least if you're walking down the side of the street, you don't have a whole lot of rights, as I've explained many times, when you're in your car or maybe even when you're in a school or an airport anymore. But in your home, at least, you have retained the original strength of the Fourth Amendment theoretically in your home. The home still receives the greatest protection under the Constitution, and it still really is our castle, the only castle we have at all under our Constitution at this point. You have the castle doctrine, you have stand your ground laws, which have expanded in the states. And now, really in 2021, we've begun what is really the decade of the Karen. And as we're going to see shortly, probably, as was demonstrated much of last year, the debate over the Second Amendment really should be over. The police aren't going to protect us. What we need is more freedom to be able to protect ourselves, not less freedom. So that's what this is all about. That's what I'm all about. We don't need more police. We don't need more jails. We don't need more laws. We don't need more politicians. All we need really is more freedom. What I'm going to talk about here today are updates in two different cases, and that is the Drug Task Force search case and also the family judge search case. So I have big updates in both of those cases. If you don't know what those cases are, let me see if this works. This is the video from the original Drug Task Force. And this is on YouTube if you haven't seen it. This is involving my client, Dustin Ellswick, who basically came home to check his cameras, hidden cameras that he had inside his house, to find these cops basically who were not in uniform, searching his house, going through all his stuff. And they had basically broken in through the window after cutting a surveillance camera that was on the outside of the house. And if you haven't seen this video, it documents it, but it goes entirely through the case. And this is one of these drug task forces. This was in Putnam County, West Virginia. And the big news is that on Friday, I filed the first of these cases. And there are numerous victims of these guys. But you can see them. These are police officers who are on duty, as we allege, and searching my client's house without a warrant and really with no paper trail whatsoever, looking for drugs, presumably. But that, in case you haven't seen it, that is the Drug Task Force search case, and we'll go over this in more detail. This other case is the family court judge search case. Can you all hear all that video? Last time I tried this, the video didn't transfer. But if you haven't seen this case, that's my client, Matt Gibson. And you're about to see a family court proceeding take place on his lawn and inside his house, allegedly.
It's a laughing game for them. said it's all laughs and fun for them.
Fast forward it some there. Is that audio working? Yeah, sound is fine. Oh, good. I've caught up with the technology.
I'm asking you right now, I'm putting a motion to recuse yourself because you're putting yourself in a witness capacity instead of a judiciary capacity. There's no search warrant, and they listed everything that we're looking for. Not today. Not today. I don't know where some of it's at. So, you got it? I need a search warrant. You won't get in my house without a search warrant.
Oh, yeah, I will.
All right. So that was the family court judge search case. There's not a whole lot of video in that because my client was forced to turn off the video and had his phone actually seized during that encounter. Real quick, Daniel, slam dunks on both cases. Of course, there's not a slam dunk in any civil rights case. Civil rights cases are usually pretty difficult cases to litigate. Some of them are slam dunks, but they don't require a whole lot of litigating. These are both difficult, both difficult cases. This one much more difficult, involving judicial immunity. So that we'll go through that. And the judge in that case just today filed a motion to dismiss. So I'll show that to you. We'll go through it, and hopefully I can explain that. All right, but first, before we get to the updates in those cases, just to make sure we're on the same page, let's quickly just run through what the law is here. So the Fourth Amendment, we know what the Fourth Amendment is. That protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure. That's the Fourth Amendment. So with few exceptions, warrantless searches are per se unreasonable and therefore unlawful, or if you prefer, illegal, as a matter of law under the Fourth Amendment. Okay, at the very core of the Fourth Amendment is the right of a man to retreat into his own home and be free from unreasonable government intrusion. With few exceptions, the question of whether a warrantless search is reasonable and hence constitutional must be answered no. So any search in the home, is there a warrant? If there's not a warrant, it's presumptively illegal, presumptively unconstitutional, presumptively unreasonable. All those words, for our purposes, mean the same thing. Searches and seizures which take place inside a person's home are illegal, which means they are illegal by default, according to the Fourth Amendment. On the other hand, outside your home is different, because these protections only apply where there's a reasonable expectation of privacy, according to the Supreme Court. Outside the home, you don't need a warrant, or cops don't need a warrant, unless the courts have held there's a reasonable expectation of privacy in whatever they're searching. So to the contrary, the U.S. Supreme Court has found that there is no presumption outside the home where a warrant is required, because as the SCOTUS has ruled, for most places outside the home, there is no expectation of privacy. That could be bank accounts, curbside trash, open fields surrounding one's home, and it goes on and on. But the searches of a home by the government, by law enforcement, do require a warrant or a valid exception. And as of right now, there's only two valid exceptions, but there's a third one that's currently pending at the Supreme Court. And that is the so-called community caretaking exception. But for our purposes right now, all we have is consent or exigent circumstances. So law enforcement may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with injury. That's known as exigent circumstances, and generally means some sort of emergency situation. The need to protect or preserve life or avoid serious injury. And that, according to the courts, is justification for what would otherwise be illegal, absent some sort of exigency or emergency. And again, that is an objective rule. So that doesn't mean that an officer subjectively thought that there was an emergency, even though there really wasn't one. It's an objective standard. It doesn't matter what his actual reason was or whether he was wrong. It's whether the so-called reasonable officer would have thought that an emergency existed based on what they were actually confronted with. So let's get to the Fourth Amendment law surrounding the house. Sharky's machine. Do we really have rights? With respect to your house, what I'm trying to say is yes, you do. With respect to your house, because it's on them to prove an exception. If they searched your house without a warrant, then you don't have to do anything else. That is, as a matter of law, presumptively unconstitutional. They would have to then prove that either they obtained voluntary consent or that exigent circumstances exist. Now, outside of your home, not the same thing. If you have a reasonable expectation of privacy according to the case law, then there are these protections that would require a warrant and so on, for which there also could be exceptions. And there's lots of different cases. Like I said, again, curbside trash, the GPS information with your car, bags inside a trunk, a backpack on a on a pedestrian. There's all sorts of hundreds or thousands of cases on these. Now, the first case that we got into, again, this was the drug task force guys. And if you haven't seen this video, this is from like January 15th of 2020 that this video was originally put up there. I'll also note that at the very
day in and day out, fighting
this was the ending of the first video that was actually taken out because the media, this channel, threatened to sue me for copyright infringement.
That is here day in and day out, fighting crime.
And that's just not the battle I wanted to fight here. So keeping my eyes on the prize. But this is what was taken out of the original video, and this was a fluff piece basically showing this unit of guys. This is just in this county, the Special Enforcement Unit, and I hadn't heard of them before my first client came to me with this case, with the video he had from his house. But then I got to searching, and I found this sort of fluff piece from the local TV news where they're following these guys around and they're going and knocking on doors and explaining what they do.
They'll sit down and talk to you.
They're out driving the streets of Putnam County.
And this is basically what they do is they go up and they don't dress like cops. They dress like they're just, one of the guys from the trailer park, I guess. But then they also have guns. And then they sort of would, try to get information out of people by, as some would say, intimidating them, as some would say, acting like a gang. But after this original video got up on YouTube, and I'm talking about this one that I'm playing right now, I started getting calls from people just all over with their own stories of, yeah, these guys came in my house, or I had an encounter with these guys. And I heard lots of different stories where they were doing the same sort of thing. There was some video in at least one other case. Now, nothing like this. And this is just, as I've said before, one of the creepiest things I've seen. And that is police officers literally in your house going through your stuff when they think that no one's watching, after having cut a surveillance camera wire on the outside to disguise what they were doing. Crawled in through a window, and they're looking for drugs, looking everywhere. And didn't document it, weren't going to say anything about it because they didn't find any drugs. But he just happened to have these cameras on inside his house. So I just thought it was really one of the creepiest things I've just ever seen. And you can see, look, there's this gun, as someone called that Mexican carry style, just sitting in the front of his pants. They went through everything. They pulled his guns out of the closets and they photographed his guns. Right here on the counter of that dresser, you can see the ashes of my client's dead friend. And at one point they grab, you can see it maybe right there. He grabs the ashes, and right there he's looking at them with the flashlight. He starts shaking them around. Maybe he sniffs them, ultimately runs them through a drug field test kit to see if they're drugs, and leaves the empty field test kits on the floor. And we have pictures of them as they were left, and it's got little bits of his friend's bones in it. I mean, just crazy. All this without a warrant. And when I later did a Freedom of Information Act request to see if there was some sort of explanation, no, there was no documentation, no paperwork trail. The only reason that these guys were there on paper was to serve a civil summons from a magistrate court case. And that's it. So I started getting calls just from all sorts of people. So the really the worst story that I heard was from this family that lived there in Putnam County. And they were afraid to really come forward about what had happened until they saw this video making its rounds on social media. And they reached out to me, and I drove to their house, even with my family. And I think my wife and kids were with me, and we sat down in their living room and I met with them, and they told me the story. And I'll tell you what, they didn't have a video because most people don't have hidden cameras inside their house, unfortunately. But they told just a compelling story, and combined with the fact that this video does exist, as well as other people who were willing to testify as to similar stories, I think it will be very credible. So here is well, if you look at the website at thecivilrightslawyer.com, I put a copy of the full lawsuit on there. Let me see if I can bring that up. All right, so there's the website. It's the last post on it. Well, I haven't put it up yet, but the next case I'm going to talk about, I have those things up. So I'll have it up there shortly. Let me just bring it up directly. All right, here it is. So this is the case that was filed on Friday, and this is filed in federal court in the Huntington Division because it happened in Putnam County. And if you have a federal civil rights lawsuit that occurred in Putnam County, West Virginia, that's in the Huntington Division, so that's where it goes. So this is a Section 1983 lawsuit alleging the deprivation of federally protected rights by government officials, by police officers who are acting under color of law. Notice that they're all sued individually. And also as a defendant is the employer Putnam County Commission, the political subdivision, and that's not for a direct civil rights violation claim. That's for what's called a Monell claim. And I'll get to that. Also included is a John Doe for an currently unknown supervisor to be able to make a claim for supervisor liability, which is, I think, applicable given the facts in this situation. So it's a search and seizure type 1983 claim. So here are the facts. January 15th, 2020, I had originally uploaded the video that I was showing you, showing several police officers, most of whom were not wearing uniforms, entering my client's house, Dustin Ellswick, and cutting the wires, illegally entering the residence, illegally searching the residence, and getting caught on these hidden cameras. They had entered through an air conditioning, they had entered through a window, and after pushing out the air conditioning unit, illegally searched the home, presumably looking for drugs. They didn't find any. They did take his firearms out of the storage case and took pictures of them, et cetera, et cetera. I already told you. All right, they left the house ransacked and left everything, out where they had left it. So these guys were all part of the Putnam County Sheriff's Office Special Enforcement Unit, or the SEU. And that's who these guys were. And I named them. I'll go back to it. This is who you see in the video. Brian Hall was the main guy. Xerxes Ramadi was the bigger, fatter guy. Scott Lothar, really, you only saw him at the end of the video. He was outside in tactical gear. You see him cross the bridge. He wasn't observed on the video inside the house, but he was sort of guarding from the outside. Brian Lockhart and Kenny Davis, I don't think wasn't in that video, but he was involved in this case that I'm going to tell you about. Brian Lockhart was in the video, and these are all sheriff's deputies who are all technically employees of the Putnam County Commission, which is the actual political subdivision in West Virginia, who is the employer. Now back to the facts. Those are the defendants. These guys are all part of this SEU, the Special Enforcement Unit. And again, I showed you that fluff piece from the local news. This was just sort of a, fight crime sort of deal where they sort of look like they're cool to talk to, or they're intimidating looking when they're trying to get information out of you. That was just sort of their shtick. And let's see. And what I learned is, after talking to, dozens of people who had interacted with him around the time of this video, here's what they would do. They would obtain tips about individuals who may be in possession of, mostly what I heard was marijuana, who may be selling marijuana. So they'd find somebody who would have some pot, and they'd, intimidate them, threaten to charge them, and say, look, we'll let you out of this. You tell us who you got it from. And then they'd go to the next person's place. So they'd make a warrantless entry into a residence of a suspect in possession of marijuana. When they found it, they would get a tip from that person. Then they'd go and threaten and pressure the suspect to give them another tip, or to identify another individual who's in possession of marijuana also, in exchange for not being arrested or charged. Then the SEU members would leave, taking with them any marijuana they seized, along with any cash or firearms that they had located in the illegal search and seizure. So that is sort of the important part here, is not that they were doing this, which I'm sure other drug task force do, but that they're doing it with no warrants, and then they're taking the cash, the drugs, and any firearms they find, and they're leaving no paper trail. So no police reports, no warrant applications, no charging documents, no inventories following their search and seizure. What happened to the seized marijuana? What happened to the cash money? What happened to the firearms that were seized? They would disappear into the possession of the SEU members without ever being properly documented. How do I know that? Well, we've alleged it in the lawsuit because we've served the employer with FOIA requests, Freedom of Information Act requests, and received little to nothing in response. Only, I think maybe in one case or two cases was there any paperwork at all. In only one case was there actual documentation of, all right, we actually had a raid and entered the house and looked for or found something. Only one that I looked at. So here's the allegations pertaining to what they did to this actual family. So this happened on April 18th, 2019. The Johnson family were at their home. This is located on Poca River Road in Poca, Putnam County, West Virginia. So April of 2019, sort of a suburban, nice little road along the Poca River in Putnam County. And there was actually some road work taking place right across the street from my client's house. And so there were plenty of witnesses present who were on this road work crew. And there was a bunch of people at my client's house, and they had family that were visiting from Virginia. And this is a multi-racial Hispanic family. So the father is your regular white guy from West Virginia, and he married a woman who I believe was from Peru. Everybody in the story was in this country, either a citizen or in this country completely legally, completely documented. No illegal aliens were involved in this at all. So it shouldn't even have to be mentioned, but you'll see why I have to mention it. So it's a really nice little house, a split level style house. Their home, extended family present. Everybody's having a relaxed afternoon. And I believe that the father, Bliss Johnson, was helping put together a cabinet with his father-in-law. And next thing you know, these guys arrive. And suddenly, these guys, defendants Hall, Ramadi, Lothar, Davis, and Lockhart, were all present, none of them wearing uniforms. So these police officers, they were on duty, acting as the special enforcement unit, exited their vehicles, and these are police cruisers, unmarked police cruisers. These were not personal vehicles. They approached the Johnson home, and they straight up entered the Johnson residence, letting themselves in the front door. They didn't have a warrant to enter the home. They didn't seek, nor did they obtain voluntary consent to enter the home, nor did they have exigent circumstances to enter the home. And remember, we went through the law. Police officers entering a home without a warrant, presumptively unconstitutional. The exceptions which they have to prove are either voluntary consent or exigent circumstances, some sort of emergency. As we've alleged, no warrant, no exigent circumstances, no consent. Apparently, there had been a tip that there would be some marijuana in the house possessed by the son. Instead of investigating that, doing actual police work, assuming that that was a priority for them, instead of seeking a search warrant, the defendant officers instead just barged into the house, as other people have alleged they did, just to find the marijuana. So here's how they did it. They began knocking on the front door and shouting. Within a few moments, they just let themselves in and searched the home, finding what appeared to be a dead marijuana or possibly hemp plant in the basement belonging to the son, Bliss B. Johnson. They were asked by the father, "Where's your warrant?" The officers responded they didn't need a warrant because they already had probable cause since they found what they believed to be a marijuana plant in the basement. Now, you don't have to be a lawyer to know, because I already explained it to you. Is that the standard for seizing marijuana inside somebody's house, or alleged marijuana, or a dead marijuana plant, which even could be a hemp plant? Is that the standard probable cause? Oh, too late, we found it, so we don't need a warrant. Obviously not. Probable cause is the standard for a pedestrian walking down the street, and they have to have it before they search, not after. So they got two things wrong there. Still needed a warrant, but you'll see how they sort of did things. And this was particularly really made me very angry. During the search of the home, the officers forced this entire family. Again, we're talking about kids. We're talking about at least one family member who was developmentally disabled, who, although was of adult age, was like I said, disabled mentally, and forced them all, and the extended family, the grandparents basically, who were in from, I believe, Northern Virginia, originally from Peru, but lived in Northern Virginia. They forced them to all sit around the kitchen table where they were guarded in their own home, restricted from moving away from this kitchen table. Then they were threatened. They told them that they believed they were selling heroin. Somebody had given them information that they were selling heroin. So the father sort of motioned around the room and said, "Does it look like we're selling heroin? It's just your regular sort of suburban house." Everything from grandparents to grandkids, just sort of enjoying the afternoon. And again, this was a mostly Hispanic family, except for the father. And what did they do? They threatened to have them deported. So they just incorrectly assumed that there were illegal aliens in the house. They threatened to put the occupants of the house in handcuffs and demanded repeatedly, "We need to see some green cards." The defendant officers were also threatening to call CPS to seize the 4-year-old child who was in the home, as well as the adult child with Down syndrome, because the rest of the family, as they threatened, was going to be taken into custody. And they also rummaged through the luggage of the extended family from Virginia and went through their medications and asked them detailed and private questions about the prescriptions that they had in their luggage, which were completely legal and violating really their private healthcare information. But it still gets worse. Hopefully I'm not losing you here. And where do you deport an American citizen? That's exactly right. Ed, well, that escalated quickly, didn't it? This was sort of their MO. You know, they'd bust in, they'd find the drugs, hopefully, and then they would just sort of use that as leverage and kind of circle the people and be like, look, you're in big trouble. You know that, and we can even charge you with a felony. So you're going to have to help us. You're going to have to tell us, you know, where we need to go next. And that was sort of the idea of this unconventional unit to really fight drugs. But this is where it ended up. So here's where they went. While the family's being guarded in the kitchen, one of the officers locates a safe under the father's bed. He was physically forced by the officers to use the combination and open the safe. Inside the safe was cash savings that they had been saving for a long time of around $10,000. Also in the safe were several, I shouldn't even have to say this because it doesn't matter because they didn't have a warrant, several lawfully owned and possessed firearms. And I'm not even talking about ARs or anything. This is like a shotgun, bolt action style hunting rifles, that sort of thing. The type of thing that you have in the gun safe or the gun cabinet or even the closet of really any home in West Virginia. So what do? The officers confiscate the cash and the firearms. They force the family to sign some sort of document. And I say some sort of document because they weren't given a copy of whatever they were forced to sign, declaring that they were donating these seized items to the Putnam County Sheriff. And I believe that was the firearms. You know, the cash wasn't mentioned that I know of. Again, they didn't give this family a copy of this. And for the reason that I'll tell you in a few minutes, even the agency itself didn't have a copy of whatever was signed because it apparently doesn't exist. They were threatened with physical harm if they didn't sign this document, whatever it was. They threatened to take one of the family members to the basement to choke them to death. They were threatened with criminal prosecution, with being deported, with also having their children seized by the CPS, which is a much more realistic threat this day and age. The father and the son were forced to sign consent to search forms, despite the fact that the house had already been searched. They were told that if they didn't sign the paperwork, they were going to jail. The bigger guy, Ramadi, threatened that he would take Mr. Johnson downstairs. I believe that was the son, downstairs and choke him to death, I believe he said. Neither the donation forms nor the consent forms were subsequently located by Putnam County's lawyer after we served them with a FOIA request, with a Freedom of Information Act request. So if this is true, which I believe it is, that there was a search, there would have been on file a warrant that was produced with our FOIA request, or that would have been of record in the courthouse. If items were actually seized legally, there would be documentation of what was seized. There would be inventory forms. There would be at least whatever document they had them sign to make them think that there was paperwork and they were giving them these items. But that never was produced by Putnam County's lawyer when we served them the FOIA request. And these FOIA requests, again, are all being served after this video had already gone viral on YouTube. So everybody knew about it, and law enforcement there. And as far as their lawyers, I mean, I made sure that they had lawyers. I was dealing with their lawyers to get me the documents. If I'm misunderstanding something, that's fine. Get me the documentation. If the clients misunderstood what was happening, if there's a reasonable explanation or any explanation for this, then show me the documents. Nothing exists. They also searched the son's car in the driveway That's Bliss B. Johnson. That was the son. They found $300 in cash, and they kept that as well. One of the officers, it was recalled, put a rubber band around it and just stuck it in his pocket. Never to be seen again by this family or by any paperwork with the employer. So what did they tell them was the reason why they were taking the guns anyways? Well, they told Mr. Johnson they were taking his guns so he couldn't seek revenge on them. Now, mind you, Mr. Johnson is not a prohibited person from possessing firearms. Instead, this man, this father, is a military veteran and law-abiding citizen. Period. After the search, these guys instructed the son. It's confusing because they have similar names. The son to meet them at an abandoned building in Taze Valley. That's in West Virginia, where they pressured him to sign donation forms. I'm not sure if those are additional forms or that's when he signed the forms and the father signed them back at the house. They also attempted to get him to give them information of some other target who may have illegal drugs that they could kind of go do the same thing to. However, he had no information to provide. After that, they were deeply afraid of these police officers. They were too afraid to tell anybody what had happened. It wasn't until they saw this video, the Dustin Ellswick video, that video, that they really had the courage to come forward and contact me about what had happened to them. And they didn't even know all the details. They knew what they saw in the video. But when I talked to them, there were other details that they didn't know that weren't released that really matched exactly what I already knew and had heard from other people, because these weren't the only people that contacted me with the story. So just regarding the, how we know that there was no paperwork. So you look at this little footnote. So March 2nd, 2020, I served the Freedom of Information Act request on the Putnam County Commission. This is the employer, through their counsel, requesting any and all documentation of any kind relating to an April 18th, 2019 search of their home. The response provided that they had no records pertaining to the event. The only thing that they had on file was a May 2019, which is after this search. It was just a name and address for Bliss B. Johnson. I think that was the son. So after the search, no documentation from the time of the search or before the search. So there was no documentation of the fact that they were at the Johnson residence. And that's what I expected. That's exactly what I expected. If there's that documentation, fine, show it to me. But I was positive. I was pretty positive that there would be none. That there'd be no documentation, just like there wasn't for the Ellswick search. The police officers failed to document the fact that they were at that house, that they were in that house, that they seized cash from that house. They failed to document that they seized firearms from that house. To date, it's been over a year since that FOIA request. There still has been no supplementation of our FOIA request of any found documents of, oh yeah, sorry, we did have a search warrant. Here it was. We just missed it. Nothing. There's been nothing. Absolutely nothing provided. So before I get to the counts themselves, did we cooperate with internal investigators? Yes, we did. I went and met personally with the two detectives that were tasked with investigating this matter, investigating this guy's, the internal investigation. I met with them, opened my file to them, gave them anything and everything they wanted, the original Ellswick videos. I brought Mr. Ellswick and the other witness that we had to meet with them. I sent them the video, another video of somebody who didn't even want it public at all, didn't want to file a lawsuit, didn't want to be involved. I sent them that video with the person's permission, gave them the details of other cases, including this one. And I don't know what happened in the internal investigation or whether there was any discipline. I I mean, I'm sure there were no criminal charges or anything like that, but absolutely, it wasn't like we filed a lawsuit, went straight to trying to get money out of them. We tried to go the disciplinary process route first, and really that was, because it was the right thing to do. We had, me as a civil rights lawyer, I had nothing financially to gain because of that, because if the agency decides to throw a police officer under the bus and say indict them, criminal charges. I've had that happen before. You know what happens? The insurance company then sends me a letter stating that, look, if a crime committed, that's excluded under the insurance coverage. We're not covering that. So we had nothing to gain by that, but it was just the right thing to do. Daniel, investigation results are public record. Not necessarily, not necessarily. Investigation results are, there was an investigation and there's going to be some documentation of that, I assume. And it's probably not something they're going to hand over as a public record in a FOIA, but it will be handed over as discovery and litigation. So I don't know what happened with the internal investigation. I heard things, but I don't know what's true and what's not true. So no, generally they are not, personnel files are not public record. But a lot of times when they take action, there will be some press release or public aspect of it. I just heard nothing one way or the other in this case. David Benner, no documentation that it must have been theft. How much is kicked back to the sheriff at all? I have absolutely no knowledge of that. I don't know. As far as the items that were seized, there's just no paper trail whatsoever. Now, they did get a new sheriff after all this stuff happened. And I'd heard things through the grapevine that the new sheriff, part of, why he wanted to be sheriff was to put an end to stuff like this. I don't know if that's true or whether he ever did. There are agencies out there who are in a good position to do things about things like this. One is in Washington, D.C., but I think they're a little bit too busy going after insurrectionists and things of that nature to be bothered with, corrupt police officers. And in fact, all they had to do that even an internal investigation really couldn't do, and that even the state police couldn't do, all they had to do was send agents in there and be like, hey, were you, because they knew about the original video before it went to YouTube. They had the opportunity. All they had to do was go in and say, hey, were you ever at this house? Were you ever inside this house? Were you inside this house on such and such date? If so, why? If they said no, boom, you had them. Why were they in the house? They've never explained why they were seen in this video. Why were they in there? What's their side of the story? I don't know. They haven't had to tell it yet to me. Have they told it to internal investigators? Have they told it to criminal investigators? I don't know. What is their explanation? What explanation could there be for being inside someone's house? Either you had consent to be there, or you had a warrant, or there was some emergency happening inside. Those are really the only exceptions. Now, what do I suspect is the reason? And I've said this before. What do I suspect was their justification in their minds? Well, here's what I think was going on, is they had what they were there to serve that day. Now, they knew, we would argue, they knew that my guy wasn't home, that he was at work. They knew that because there was a phone call to the employer. Again, new information. No one knows this yet. There was a phone call to the employer earlier that day, as if checking to make sure that my client was not home. So they go to the home, and there's several police cruisers there. Again, they're on duty. They're in police cruisers. No uniforms, but they're in police cruisers. They got guns. At least one dude's on the video. You'll see him with a sheriff badge on. Where is he?
January.
No. There he is. All right. So see that guy? That's Lothar, Scott Lothar. So it says sheriff on his badge. So, I mean, it is really no way to claim that you weren't there in a law enforcement capacity, but I suppose they could, maybe they have to. But here's what they're going to say is they were there to serve civil summons paperwork, because here's what happened is the client's mother somebody saw a bunch of police cars at my client's house and contacted him. And then his mother went to check on, all right, what in the world's going on in my son's house? And she had a friend, a witness with her, and they confronted these guys at the house. So boom, they were caught red-handed. And that's how we know about it. And they didn't know they were on video at the time. And so that's when they said, oh, well, we're here to serve this. And the mother was kept away from the house, but she was shown the civil summons paperwork. And it was a eviction summons. So it was an allegation he hadn't paid all his rent yet. And he was the beginning stages of an eviction lawsuit had started. There was no court order or anything. It was just a lawsuit that you have to serve on people. And ultimately, he wasn't evicted. He had made a deal with his landlord over what the dispute was, and it never proceeded. But they were there to serve a civil summons. So here's what their allegation might be: is we had the permission of the landlord to be in the house. That might be what they were going to say. So that brings up the question. All right, well, say the landlord hired these guys or sent them there because they weren't the process servers for the county. And I can go into who the process server was. It was neither of these guys. The real process server wasn't there. So I don't know how this ended up happening, but they were there to serve the paperwork on behalf of the landlord procedurally. So what if they say the landlord gave us permission to be in the house, and even the lease says that we get to go inside the house, or the landlord gets to go inside the house to inspect it? Well, that doesn't do much good for them, because there's like a 1950s or 1959 U.S. Supreme Court case that says a landlord cannot give the cops permission to go inside the tenant's house to search. Period. I mean, very, very well-established case law. That was from a moonshine case where the landlord had every reason to believe there was a legal whiskey still inside his structure, that they weren't even real tenants, that it was just a front. Called the cops. Cops, ironically, climbed in through the window, ended up convicting the guy of all sorts of crimes for running a moonshine still inside this landlord's structure. And everything's thrown out, goes to the Supreme Court, and they hold that no, that was an illegal search. A landlord cannot give permission to enter a tenant's house. They still have to go get a warrant. So if that's the explanation, then it's just, they were mistaken about what the law is, if that's their explanation. So that won't do any good. So really the only way out of that is to somehow come up with a search warrant. Because there's no way to come up with consent. There's no way I don't see how you could come up with an emergency or exigency excuse. And I'm not going to give them any theories to work off of, but there's really no excuse for it. So here are the claims in this new case. Okay, count one, basic, unreasonable, and therefore unconstitutional search and seizure, violation of the Fourth Amendment. And you'll see that it's very, very specific, so that it doesn't get knocked out on a motion to dismiss. But it comes down to this: no objectively reasonable police officer would believe that they possess the authority to enter this home without a warrant, without voluntary consent, and without exigent circumstances. And same thing for seizing items, including cash money, firearms, even a dead marijuana plant, without a warrant, without voluntary consent, without exigent circumstances. So again, this is about a different search than the one from the video. And this one was filed first because the statute of limitations approached first. So this happened like 5 or 6 months before the one from the video. And this happened under color of law. They weren't there in any other capacity. Now, count two, Monell claim. Remember, the county commission itself is a defendant in the case. That's not because the agency is liable for the conduct of their employees. You have to establish what's called a Monell claim, that they had basically an official policy or a pattern or practice of engaging in civil rights violations. And this might be one of the rare successful Monell claims, because this is sort of what we had here: an official policy, custom, and practice of violating the rights of homeowners in that county, engaging in a pattern and practice of warrantless searches and seizures under auspices of fighting against illegal drug use and crime. They wore no law enforcement uniforms, gave the appearance they were acting sort of outside the law, no rules, no documentation, no paperwork. And this allowed the use of intimidation and sort of a perceived lawlessness to more effectively and efficiently acquire information and sources. And as you've heard me say before, if you've watched my videos, the Constitution is designed in such a way as to not be efficient, as to not allow the government to be efficient and effective. So that's not the standard of constitutionality. It's not, well, this works better. No, it's supposed to be hard to go in someone's house and search. I mean, that's part of the reason that we fought the Revolutionary War. All right, so in accordance with that official policy and a practice, what they did in this case to this family was also done as a part of that same practice that they had. And they did commit other similar violations against other victims in Putnam County, West Virginia, others who will be the plaintiffs in lawsuits, and others who may just be witnesses. We'll see. Count 3, supervisory liability. This is the John Doe. Now, who was the supervisor of these officers? I don't know his name, but definitely he had actual knowledge that these guys were engaged in conduct that posed an unreasonable risk of constitutional injury to the plaintiffs, that they would be searching people's houses and seizing their stuff without a search warrant, potentially, or any other exception to the search warrant requirement to the Fourth Amendment. So I can't imagine how the supervisor was doing a good job of supervising these guys. So let me put the video back up, go back to the end.
Here in Winfield
I mean, heck, everybody sort of knew if you watched the local news.
Look for fugitives from around Putnam County, and this is the group that is here day in and day out fighting crime.
When it comes to fighting crime, this group can't and doesn't do it alone.
The more people that find out we're out here, the more information we're getting.
They're a group of 4 Putnam County deputies, but together they make up
Those
the
are my
Special
words
Enforcement Unit.
on the top, obviously.
They're not undercover, even though they're not in uniform.
Most people are more relaxed with us when we're out of uniform. They'll sit down and talk to you.
They're out driving the streets of Putnam County every day, checking on tips called into the agency's anonymous drug tip line.
A lot of times it is people calling in on their neighbors or people in their neighborhood, or they observe a lot of traffic, unusual traffic at different times, late at night.
They also serve warrants and track down fugitives in the county. Just recently, the group became deputized to work with the United States Marshals Cuff Task Force.
The Marshal Service, not only do we go with them, but they're willing to come to our county and serve warrants as well.
Since their formation, hundreds of arrests have been made. They've captured accused heroin dealers, uncovered drug operations, nabbed fugitives, and all with your help.
If they wish to remain anonymous, they're going to remain anonymous. We don't tell people where the information come from, because we want more information. We want people to call us all the time.
Proactive policing made possible by those who don't want crime in their neighborhood.
All right, so that's like the verboten news footage I had to take out of the original video. I didn't have to, but I think it would have been a distraction to fight them over that. So it'd be hard to claim that nobody knew that these guys were doing this sort of thing when that was sort of the shtick that they were allowed to run with, of like, all right, you're going to be this like unconventional like Delta force of Putnam County, where you're gonna like bust into people's trailers and find out who their drug dealer is and so on. So that's that case. Again, these cases are going to kind of run together, but it's been a long time coming, and people have asked me over and over and over again, what's going on with that drug task force case? Well, it's now come to fruition. Now we're going to litigate it. We're going to get the opportunity to take depositions and see what their official side of the story is. And again, why did it take so long? Well, we participated in and gave them every opportunity to conduct their internal investigation, waited and waited and waited to hear, waited and waited to see if they were going to sort of make things right with the clients as well. You know, we don't have to file a lawsuit if they're going to, step up and make things right. But they didn't say they weren't going to, but they just never did and kept putting it off. So here we are. So now we're going to litigate it. So that is the first of the drug task force cases, and there will be others filed very, very shortly, including the Ellswick one. Again, their choice, not ours. Now, the other, well, let me check, see if there's any recent questions here before I move to the family court case. Yes, West Virginia Freedom Task Force. Absolutely. The shirts tell you that, the 1776 and the American flag on the shirts. Yes, they're fighting for your freedom while they're in your house, searching through your stuff. David, what does the supervisor know? LOL, I would be checking on individuals and units even late at night and early dark 30 in the morning. If you had to be babysat, you did not work under me. Well, I think that might play a part in it. I mean, clearly I guess at any job, it'd be great to be like, all right, if you're a cop, I'm not saying I would not ask for this. All right. I want to both be a cop, work at your agency, but I don't want to wear a uniform. I want to wear like just grunt style shirts and jeans. And I want to like Mexican carry my Glock, but I won't carry one in the chamber so I don't shoot my junk off. And I want no supervision. Now, that one guy could have had a holster technically. I didn't see whether it was a Glock or not. There are little holsters like Raven, Vanguard concealment holsters that I've used myself that you can appendix carry like that. And you can't tell that they just sort of cover the trigger on a Glock because that they don't have a manual safety. So I'm sort of being tongue in cheek. There could be a holster there. I don't know. The point is that there was really no supervision. And that's the point. If there's no supervision, you're turning these guys loose on the local trailer park. And I'm being facetious because the clients I filed this on behalf of are not in a trailer park. Very nice neighborhood, nice home, nice family. The Dustin Ellswick video you can see is a rural farmhouse. I mean, I think it was a log cabin, actually. It wasn't a trailer park, wasn't a drug area. I mean, these are just regular good people that are being terrorized by what is a bunch of cops looking and acting like a gang. Those are the allegations. And therefore, I would like to hear what the supervision was. And if the defense is for the supervision that, well, there was no supervision, you can't blame me, that sort of makes the claim that, well, there was a lack of supervision because, you did set up this SEU and you did turn them out onto the community and you even told the news about it, but you didn't watch them at all. You didn't look to see whether they were getting search warrants or whether they were seizing things. And if so, what was happening to the things that they were seizing? Okay. And I'll do more on that case as this progresses. So now to move on to the family court case. Again, that's this case.
There's no search warrant. They listed everything that we're looking for.
That's the family court judge with her back to you. That is her bailiff. I believe his name is McPeak. Standing to the right, that's the ex-wife's lawyer that you can hardly see in the green suit, and then that's my client, Matt Gibson, to the left. So watch that video if you haven't seen it. This is the complaint that we recently filed. I'll just briefly show you the complaint. So that's the complaint. Also, Southern District of West Virginia federal courts. Now, this one, instead of Huntington Division, this is Beckley Division because it took place in Raleigh County, West Virginia. Also, a 1983 case. Also, for an unreasonable and therefore unconstitutional search and seizure of the plaintiff's home. Now, this is a more recent search. This happened on March 4th, 2020, right before this giant state of emergency was declared that we're still living under. Again, that's a different video. I don't need to go into that. Plenty of other videos that you can hear my opinion on that. So we filed this lawsuit. I've gone over it before, but basically a 26-year family court judge literally searches my client's house, brings the ex-wife and her lawyer in and law enforcement, and allows the ex-wife to look for certain items of personal property and to seize them and leave the premises with them under the auspices of it being basically a home view version of a family court hearing, that they literally left the family court and resumed the hearing in my client's front yard and then took it inside the house. So when I first saw the video, I was like, this is crazy. I've never heard of this before. We put it on YouTube. The news picked up with it, and also the Judicial Investigation Commission picked up with it. And they ended up investigating the judge and filing a formal statement of charges against the judge and one other judge who was doing the same sort of thing at least twice. And that's still really being litigated. But ultimately, we filed this federal civil rights lawsuit, and that's it. You can read it. It's up on the website. And what happened today? So there's news today in that case, and here's what happened. So we just filed this lawsuit on March 22nd, and we served all of the defendants. It just had them served with a copy of the complaint and the summons. And so now all the answers were due today, and we had several motions to dismiss that were filed. And so that's what was filed today. And if you look at the website, thecivilrightslawyer.com, you will see the motion or the memorandums that were filed arguing for dismissal of our lawsuit. It's exactly right that and they wouldn't have gotten away with it if it wasn't for us meddling kids. Bubba, no rights in your house, no rights in your car, guns being taken away, America, land of the free. Well, this is a really interesting case when it comes to home rights, because there are people arguing, including family court judges, that this is absolutely legal for them to do, that there's no Fourth Amendment right to keep a family court judge or any judge out of your house if they want to go search your house. It's really bizarre. And here is again, if you go to the website, I have these filings, civilrightslawyer.com, but we can look at a better version of them. So let me look at first. Do you want to look at the judges first or the cops first? Let's look at the judges first. That's the most interesting. Okay, so here's the judge's filing that came down today. Just received it. I've had enough time to breeze through it and jot down some notes, basically. But this is it. This is written by the lawyers, the defense lawyers. So they go through all the legalese. And let me get to the substance of it here. And so this is absolutely expected. So here's their big argument. As a judicial officer acting in that capacity as a judge, Judge Goldston is absolutely immune from plaintiff's claims. So it's well settled that judges are absolutely immune from a suit for deprivation of civil rights brought under Section 1983, even if such acts were allegedly done maliciously, corruptly, or in bad faith, and no matter how erroneous the act may have been. And however injurious in its consequences the judicial act may have proved to the plaintiff. So, as they note, it's a form of absolute immunity. It doesn't merely protect them from being assessed damages, but also from having to participate in a lawsuit at all. And that's the same thing of qualified immunity. It can be brought up At a motion to dismiss stage, it can be brought up at any time up to and even during the trial. And really after the trial, on appeal, it can be brought up. So qualified immunity or even judicial immunity or absolute immunity can be brought up anytime. And a lot of times it isn't brought up this early, but I absolutely expected judicial immunity brought up very early in this case, as I would if I were the defense lawyer. So just some of the other legalese, and I'll get to what the law actually is. So absolute immunity. So even though it may be unfair, a general principle of the highest importance to the administration of proper justice is that a judicial officer, in exercising the authority vested in him, shall be free to act upon his own convictions without apprehension of personal consequences to himself. Let's see. So they cite the Morellis versus Waco case. Now, this is an interesting case, the Morellis case, and I think I cited that in the complaint, but the Morellis case was a Supreme Court case from 1991. I mean, I was thinking it was 1985, but it's a fairly old Supreme Court case where a judge got sued by a lawyer for a Section 1983 claim for excessive force. And here's what the judge did. The judge basically said to her bailiff, or to his bailiff, it was a guy, he said, I want you to go get, lawyer John Doe or whoever he was. Maybe it was Morellis. I want you to go get this guy. He's in a different courtroom. I want you to go get him. And when you get him, I want you to use excessive force. Bring him back to me and make sure you use excessive force. So being the trustworthy bailiff, the bailiff went out and actually did go get this lawyer and used excessive force when brought the lawyer back in. So the lawyer sues the bailiff and also sues the judge. And the judge gets out of it in that case, claiming that, judicial immunity. And the Supreme Court held that, while it was wrong what the judge did, it did violate the attorney's rights, that judicial immunity applied because literally the judge was still sitting on the bench and it was still acting in the judicial capacity, sufficiently in the judicial capacity, when this thing happened. And I'm paraphrasing, we can go through that. And there are allegations here basically that the judge says that she continued the hearing to the client's front yard and to the litigant's front yard and was having the hearing there and then took the hearing inside the house. And because a hearing was still being conducted, she should get the lawsuit dismissed based on judicial immunity. And that is I'll get to my response to that. And here's the other thing that was bizarre that they brought up. I wasn't expecting this. Now take a look at this. They're saying that the federal courts lack subject matter jurisdiction over the plaintiff's claims due to the application of the 11th Amendment. Now, do you know what the 11th Amendment is? I know what it is. I've litigated before. Here's what the 11th Amendment says. The 11th Amendment says that a state, you can't sue the state in federal court. That's why, I can sue the Putnam County Commission, as we just went over. I can sue them in federal court. They're a political subdivision. They're not the state. So since they're not a state, the 11th Amendment, which says that the state can't be made a party in the federal courts, doesn't apply. So if I were to sue, for instance, numerous times I've sued a West Virginia state police officer, a state trooper, I haven't been able to say in federal court, I'm suing the West Virginia State Police because they're the employer. Now, one of the main reason I can't do that is because of the 11th Amendment. I can't sue a state agency in federal court unless they agree for me to do so or under certain exceptions. Generally can't. I have to name the individual officer. And so I name the individual officer, Trooper so-and-so, as an individual. And when I do that, the 11th Amendment doesn't apply at all. And so I'm not sure why they think it applies here. Because if we look back at the complaint, let's do it. Well, actually, we don't even need to look back at the complaint. Let's look at their own memorandum. All right. Let's look at the top of their own memorandum. All right, there's the judge. How is she sued? Individually, as an individual. And so in the complaint, it specifically makes clear in one of the first paragraphs that this defendant, as with the other defendants, are being sued individually, because I know you can't sue in the official capacity, because that's the same as suing the state itself if it's a state employee. You can't do that, the 11th Amendment. But it's as if they don't realize that. I'm not sure, but they pretend that this is an official capacity claim, since she's a family court judge, which is technically falls under the judicial branch, the state judicial branch, the state Supreme Court, that we're basically suing the state court system. And this is outrageous. And it's 11th Amendment says you can't do that. But we're not doing that. And so they go on and on about this. 11th Amendment says that you can't sue a judge, but we're not, or that you can't sue the state. We're not suing the state. We're suing the individual. And I'll just to pound that point home, let's bring the complaint back up. All right, here's the complaint. Wait, that's not the complaint. Here it is. All right, at the top, the judge. Well, I can't highlight that one. Louise E. Goldston, individually. And let's look down at the parties section. See parties, paragraph. Let's see, where is it? Okay, defendant Louise E. Goldston was at all times relevant here too. A judge of the 13th Family Court Circuit, has served in that capacity for approximately 26 years. At all times relevant to the allegations herein, she was acting under color of law. She is named herein as a defendant in her individual capacity. All right, so how can they argue that this is an official capacity claim where they could bring up a defense of the 11th Amendment when it's an individual capacity claim? I don't know. Maybe just trying to confuse the judge, or maybe they don't quite understand that. It can be confusing, but the 11th Amendment cannot apply to that. 11th Amendment does not say that you can't sue somebody who is a judge in their individual capacity. Now, the doctrine of judicial immunity says that you can't do that under some circumstances. So before we get to the officer's case, let's just talk about that. What does that mean? What does judicial immunity, when does it apply? When does it not apply? Again, we looked at the Morellis, I don't know how you pronounce that, Morellis versus Waco case, 1991, U.S. Supreme Court. That is the case that they cited, and it expressly says that a judge is not immune from liability for non-judicial actions, i.e. actions not taken in the judge's judicial capacity. Secondly, a judge is not immune for actions, though judicial in nature, are taken in the complete absence of all jurisdiction. So those are the two exceptions. And so how do we know when they apply? Well, it's being case law. It goes on and on. Whether an act by a judge is a, quote, judicial one relates to the nature of the act itself, whether it's a function normally performed by a judge, and to the expectations of the parties, whether they dealt with a judge in his official capacity. I'll bring this up for you as well. These are just some of my own research that I've compiled. Just some of the notes that I compiled researching this. So look, here's the law. Judge is not immune for liability for non-judicial actions. Actions not taken in the judge's judicial capacity. Whether an act by a judge is a judicial one relates to the nature of the act itself, whether it's well, let me zoom in some here. I don't know if it'll let me make this any bigger. There we go. Whether an act by a judge is a judicial one relates to the nature of the act itself, whether it's a function normally performed by a judge, and to the expectations of the party, i.e., whether they dealt with the judge in his judicial capacity. And in the Morellis case, they found that a judge's direction to court officers to bring a person who is in the courthouse before him is a function normally performed by a judge. So, all right, they rely on the Morellis case. So the judge is on the bench and says, go get that damn lawyer, and I want you to use excessive force when you bring him here. Okay, that is an act that normally judges do all around the country. They may say to a bailiff or to any other person, go get this person, go get this lawyer and bring him in the courtroom. That is completely fine. What makes that wrong? What happened? It was that the judge said, I want you to use excessive force when you did it. Now, can we contrast that situation with what happened to my client, Mr. Gibson? Is it a function normally performed by a judge to go to a litigant's house and to search their home, to physically go on their property and go walk into their home and walk downstairs and sit on the recliner and direct guys with badges and guns on where they can go, where they can't go, what they can take, what they can't take, to bring an ex-wife in the house and her lawyer and to let them take pictures or DVDs? Is it within a function normally performed by a judge to allow or to force one in their own home to open up their safe to allow their ex-wife to look in it or law enforcement to look in it? No. These are not functions that are normally performed by judges. And that's a big difference from what the Morellis case says. Judges do not search homes, period. They don't do it. So what does judicial immunity protect from? Well, it protects from judges being sued over making mistakes or acting in excess of their authority, but they're still sitting on the bench and just took it too far or something like that. This is so outside of what judges do. Nobody would expect in any court in the country, whether family court or any other type of court, that a judge is going to go search their home. Absolutely not. So the relevant inquiry is here. The relevant inquiry is the nature and function of the act, not the act itself. In other words, we look to the particular act's relation to a general function normally performed by a judge. In this case, the Morellis case, the function of directing police officers to bring counsel in a pending case before the court. So a judge's direction to an executive officer to bring counsel before the court is no more executive in character than a judge's issuance of a warrant for an executive officer to search a home. So the issuance of a search warrant is a judicial act. So therefore, what is not a judicial act? So there's a difference between judicial acts and executive acts. So the judge, a judge generally can issue a search warrant. Now, a family court judge in West Virginia can't, and that's a different area that we're getting into. But just any judge, it would be a judicial act for them to issue a search warrant, not under any circumstances to go personally engage in the executive act of enforcing that order. That is an executive function. That's what law enforcement does. Let's see. And there's a few other cases in there. And another case, the stump case. Ironically, we have a stump defendant here, but the court must assess whether the party is expected to deal with a judicial officer in that officer's judicial capacity. So generally, as a party in any court, you don't expect a judge to come search your house. Now, maybe they argue that was the expectation in this particular judge's court because it had been happening there for 26 years. But my client was not a litigant there for 26 years. This is something that he had 10 minutes notice of. He's there representing himself, and the judge says just sua sponte, which means the other lawyer didn't even ask for it. What's your address? We're going to your house. Be there in 10 minutes. And so, like I said, this judge got charged with a formal statement of charges by the State Judicial Investigation Commission. And one of the allegations, which was admitted in writing, was that the judge in this case improperly left the judicial, the role of unbiased and neutral judge presiding over a case, and entered the role of a litigant. So entered the role of representing my client's ex-wife, because this was a contempt proceeding. And one of the things that the judicial prosecutors brought out here was the admission that there was no even, she didn't even make the other lawyer prove contempt before they went to the house. So he wasn't held in contempt. This was a part of them attempting to prove contempt, allegedly. So she had basically acted as a litigant or as a lawyer against my client, that she took the role of proving contempt by taking everybody and forcing them into his house under threat of being arrested and jailed, and brought them in the house in order to see if these items were there, and that therefore to see whether or not he was in contempt. And it just violated a number of judicial rules, almost all of which the judge admitted with counsel to violating all these rules of judicial conduct. So it's going to be, I think it's a difficult argument to say that judicial immunity applies because of the Morellis case. Well, it's a little different, because when she chose to go off the bench and enter the front yard, it's a little hard to claim that. Andre, thanks. I'm the best advocate for fair, common human rights and treatment simply by embracing the U.S. Constitution. I appreciate that. Sharkies. Why do police, I guess you're talking about the other case, why do police get to investigate themselves? Well, I guess anybody can investigate themselves, any company, any agency. I mean, no one's stopping them. The fact is that, why isn't some other agency investigating them? I don't know. Karen, who is the ruler of Yard? Well, I'm glad you asked, Karen O. There is a Supreme Court case, I believe it's Florida versus Jardines, which states that the area outside of your house is really treated like the inside of your house as well. I can get that exact quote for you here. I deal with this fairly often. It's here somewhere. See, there's lots of cases. You got to go through a bunch of them. All right. Florida versus Jardines, a U.S. Supreme Court case from 2013. Officers took a trained canine to Mr. Jardines' front porch. The canine alerted for narcotics, and then they went and obtained a search warrant based upon the alert. And the question is whether, they could, even though they're not inside the house, they're on the property and they're outside the front door, but they're close to it, and they end up going on the porch, whether that constituted a search within the meaning of the Fourth Amendment. So the court held that the areas immediately surrounding the house, including the curtilage of the house, which would be the yard that this video shows, does enjoy protection under the Fourth Amendment as part of the house itself. But that is an extremely good question. Let's see. What's the DOJ's rule with self-investigation? I'm not sure that they have a rule. I mean, you can look at the Department of Justice's proposed policies and procedures for police departments. I don't even know that really they're good at this point for most purposes, but they do have mechanisms for accountability that are probably good. Some of them that have to do with unbiased and actual legitimate investigations, some sort of detached internal affairs or other agency investigating things. And in my opinion, that's absolutely a great idea. That's not necessarily a constitutional issue, because they're allowed to, run their internal, administration however they want to, but somebody needs to do it other than just depending on just private lawyers to file lawsuits. All right. The other thing that's the basic judicial immunity, and I'm going to next draft a formal response. And generally you have 14 days to file a response to a motion to dismiss like this. So within 14 days, hopefully sooner, I'll upload a response brief to this and explain pretty much everything I just explained, but just with the citations and probably thought out a little better. And here's the danger of filing these things. And a lot of times lawyers representing police officers in regular qualified immunity cases sometimes don't file motions to dismiss. And one of the reasons I think is because, well, what happens if you lose a motion to dismiss? Well, you get a court order from a federal judge explaining why, if the allegations are correct, you violated somebody's civil rights. And that can have negative consequences. It might be a lot better for the client to just settle the case and make it go away without having any court order describing your client's conduct. But if you win, you win. I guess that's worth it if you win. But if you lose, then it's not good. And also maybe the value of the case is greater now because the judge has called out the defendants. And also you have some indication on how the judge might rule on summary judgment at the next step. And also you've incurred additional attorney's fees. And the whole point of Section 1983 litigation is that if the government officer who's being sued loses, they're liable for all the attorney's fees at, $350 an hour or so, usually, a lot of times, maybe $400 an hour of all the time that I spent on the case or another lawyer spent on the case, if they're worth that money and they can prove it. So everything you do, you're increasing the value of the case if you lose. Jeez, I don't know what happened to the cigar, but all right, here's the other memorandum let me get to from the police officers. Now this deals with everybody's favorite topic of qualified immunity. All right, so this is to be expected. Separate lawyer or separate law firm represents the county defendants to this case. So you have the judge who's technically, under the Supreme Court. I mean, they're all individuals as far as the defendant being named in the lawsuit goes. But then you have the county defendants. So you have the county commission, who really means the sheriff's department, who's the employer. And then you have the particular deputies. We're all sworn law enforcement officers who are involved in this case. You have the bailiff, who was Jeff McPeak. Then you have just two other deputies that showed up to the scene after the bailiff called them for backup. You have Brian White and Bobby Stump. So this is their begging to get out of the case, basically. And like I said, basic qualified immunity, motion to dismiss. They go over the allegations in the complaint. Blah, 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 blah. Legal standard to get a motion to get a dismissal at this point. All right, here's their argument. They're entitled to qualified immunity on all counts. So again, you can get qualified immunity up front, in the middle, or at the end. So they go through just some of the basic legalese. And you have to really go down to just most of this is legalese, doesn't make any difference. You go to the relevant portions of their argument. It's going to have to do with the facts. All right. So the alleged search and God, I can't highlight this one. Alleged search and seizure happened during, these are their words, what happened during what the defendants believed was a continuation of a contempt hearing. Now whether it was a continuation of a contempt hearing, they're standing in the plaintiff's front yard and in his living room and in his basement, etc. So you're not in the courtroom. Defendant McPeak, acting as bailiff, went to the plaintiff's residence. He had an objectively reasonable belief that he could go to the plaintiff's residence with the judge as she continued the contempt hearing. And in their defense, they say the qualified immunity defense protects all but the plainly incompetent or those who knowingly violate the law, and it protects law enforcement officers from bad guesses in gray areas and ensures that they're only liable for transgressing bright lines. And all that citing case law. A bailiff is an officer of the court to which he or she is assigned, subject to the court's control and supervision, and responsible for preserving order and decorum, taking charge of the jury. What jury? Guarding prisoners. What prisoners? Well, technically, I guess there were prisoners. And other services which are reasonably necessary for the court's proper functioning. So, all right, a bailiff defense. All right. So because he was the bailiff, his presence just with the judge, she was doing it, so his presence with her was reasonable under the circumstances. Now, in reality, if you watch the video, you see that the judge uses the bailiff to force her way into the house. She threatens my client with arrest and jail like 6 or 7 times during the course of this happening. So it seems like it wouldn't have happened but for the bailiff who had a badge and a gun and handcuffs. But he sort of claims that he was just innocent. He was just supposed to guard the judge, and he was there guarding the judge. All right. And also, this is the guy that took out his cell phone during a part of this search that lasted like 30 or 40 minutes and took like 6 or 7 minutes, I think it was, a video from his own personal cell phone. And they bring this up. All right. Oh, and also seized my client's cell phone at the direction of the judge. So defendant Goldston didn't want the plaintiff to record the contempt hearing, so the bailiff seized the plaintiff's phone just as he would have done had they been in court. But they weren't in court. As such, he's entitled to qualified immunity. Plaintiff is also property. I guess that's a typo. Plead any facts indicating that the other 2 cops actually took part in the unlawful search and seizure on the plaintiff's property. I don't think that's the case. Let's go ahead and I can probably disprove that pretty easily. Let's look back at the complaint. All right, so if you look at the complaint, where is it? It's up on the screen, but I still got to find it on my screen. All right, here it is. All right, so there's 2 sections. You got the factual allegations, and then you have the counts themselves. All right, so looking in the counts themselves, all right. The other officers, White and Stump, acted under color of law. They entered the plaintiff's home as alleged herein on March 4th, 2020. Blah, 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 blah. So I allege they did it while acting under color of law. The defendants, White and Stump, deprived them of his 4th Amendment rights. Said defendants acted unreasonably. Went through all the law. So they're named in that portion. If we go up to the factual portions, pretty sure we talk about those guys. Where are they? So they weren't there from the beginning. It was just the bailiff McPeak. And then he calls for backup, and these 2 guys show up. All right, so yeah. Once inside the home, Judge Goldston directed deputies to assist plaintiff's ex-wife and defendant lawyer in searching and seizing the home's contents. Lasted a total of 20 to 30 minutes. During the search and seizure, blah, 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 blah. remove different items of personal property. All right, here we go. During the search, defendant police officers Stump and White arrived and entered the plaintiff's residence after being called by defendant McPeak. Thereafter, they began to jointly participate in the search and seizure occurring inside plaintiff's house. Shortly after arriving, defendant Stump went back outside and instructed plaintiff's witnesses to leave the property. Meanwhile, defendant Goldston allowed plaintiff's ex-wife's boyfriend, father, and brother to remain on the plaintiff's property without the plaintiff's consent. So they're referred to repeatedly and specifically when they arrived, what they did when they arrived, and that they jointly participated in it. I mean, when police officers search a house, a lot of times it's not just one guy. There's a whole group of them. And if they're all entering the house, they're all participating in the Fourth Amendment activity there, the alleged violative activity of searching and seizing somebody's house. That you don't have to allege that, you know, Officer White picked up this DVD and actually took this. I mean, he doesn't get out of liability for being inside the house and participating in it just because he didn't specifically take anything. That's not how any of this works. He was there. He entered the house. He didn't have a warrant. He didn't have voluntary consent. I guess he could try to claim exigent circumstances, that he got called to the scene and thought there was some sort of emergency. But then how does he account for him staying on the property and then continuing to enable this search and seizure to continue? So, you know, if that's the defense, I guess that's the defense. But you know, we'll see. All right, back to the request for qualified immunity for the officers. All right, so they're saying that we didn't allege that they did anything wrong. Yeah, well, you know, we kind of did. During the contempt hearing, they entered the plaintiff's home to search and seize items of personal property, blah, blah, blah. They believed it was a continuation of a contempt hearing. All right, I already read this part. Plaintiff has also failed to properly plead any facts indicating that White and Stump actually took part in an unlawful search and seizure on the plaintiff's property. I think I just read that I did. They simply responded to a call for backup when they responded to the plaintiff's residence. And responding to a call for backup is in their official duties as police officer. You know, a motion to dismiss, the court is supposed to take everything the plaintiff says is true, as the allegations in the lawsuit. This is, how many pages is this lawsuit? It's very specific. And now they tried to sneakily, sneak in other things. So they're trying to sneak in that it was a call for backup is in their official duties as police officer. Well, where's that coming from? That's not in the complaint. It's not in their, I mean, yeah, they're acting under color of law. We said that. Plaintiff has also failed to prove that that White and Stump actually seized any of the plaintiff's property themselves. And again, that's not the standard. That's not an element that the jury has to check off when we get to trial, that they actually took a DVD from the residence. No, I mean, the second they crossed the threshold without a warrant and without an applicable exception, that it's their burden to prove, because again, this is presumptive. It's his home. It's his castle. They violated the Fourth Amendment. Doesn't matter if they didn't take anything. Not a single DVD or family photo or chainsaw could have been taken from the residence that day, and it's still a Fourth Amendment violation. Whether or not they, just like the other video where they're searching for drugs, they don't find any drugs. They didn't take anything that we know of. Does that mean it wasn't a Fourth Amendment violation? No, it's an unreasonable, therefore unconstitutional search and seizure. Whether or not they actually leave the premises with anything or not, there's a seizure there. There's a search there. They didn't remove anything and store it in the sheriff's department. Well, you know, that's the point here. The ex-wife took it. They let the ex-wife take it. Plaintiff also failed to properly plead or point to any case law or statute indicating the officers were required to file a report about their presence at the plaintiff's residence. Okay. No, the reason that we brought up the fact that they didn't document any of this, they didn't file any sort of report, is because they knew they were acting outside of the law. They're acting outside of the rules. They're not allowed to be in somebody's house participating in a search and seizure with a judge and an ex-wife. I mean, what were they going to put that in a report, put it in writing? No. So their actions were reasonable under the circumstances. I mean, what we'll see. That's why they build courthouses. All right, now so that's their claim for qualified immunity. So I don't know that I can't imagine them getting qualified immunity, especially at this point, but we'll see. All right, First Amendment. So we made a First Amendment claim because my client's cell phone was forcibly taken by one of the officers, by the bailiff. And this is before the other two got there. And he was denied the constitutional right to film the fact that there were government officers and officials on his property in the process of searching his home. So if you're filming police to hold them accountable, or any government official, that's protected. You have a First Amendment right to film. So the plaintiff has failed to properly plead that defendants White and Stump seized his cell phone. That's true. White and Stump did not seize the cell phone, and we're not seeking to hold them liable for seizing the cell phone. They didn't do that. It was defendant McPeak who did that. So then they try to get him out of it. Defendant McPeak was acting on an order from defendant Goldston. So I should get qualified immunity because the judge told me to do it. Well, if you look back at that Morellis case from the Supreme Court in 1991, the bailiff also got sued in that case. And he sort of did the same thing. He claimed that, well, the judge ordered me to do it, so I did it, and actually claimed that, I should get qualified or absolute judicial immunity. And the Supreme Court said, no, all you get is regular qualified immunity. You're a police officer, you're not a judge, and it doesn't matter if the judge orders you to do something, the judge gets judicial immunity. You don't. So you still have to act as an objectively reasonable police officer. So you just get the basic qualified immunity standard. So their own case that I guess it was the judge that used that. These are the officers in a different law firm defending them. But that sort of proves that that's not going to work. Probably why they only donated one paragraph to that argument. So what I've said from the beginning is that I knew it would be a fight over judicial immunity with the judge. But heck, the deputies should have known better. They didn't have a warrant, and it's their burden then to prove exigent circumstances or voluntary consent. We'll see if they can do it. In any event, it's not a good situation for a motion to dismiss. It's really more for a trial. And this is their last argument, is to try to get the county out of it. They claim that the county has qualified immunity. Now, I was sort of surprised to see this as well, that the county gets qualified immunity. I mean, it's always been my understanding, which is the law, that counties cannot get qualified immunity. Only individual defendants, individual police officers can get qualified immunity. And they're sort of, they go all through this, but I can sort of prove this to be, I could sort of, well, I don't even need to prove this is wrong. Qualified immunity isn't an issue with Monell claims, which is just what this is. Qualified immunity is not something that can be granted to a political subdivision. So I'm not sure why they think that exists. Let's see. And they go into the 14th Amendment here, but when you see this small of a paragraph and a half devoted to it, it's really not going to apply. So the main argument for the police officers is qualified immunity. That's not going to apply to the employer. They can't get qualified immunity. The main argument for the judge to get out of it is judicial immunity. That's a much better argument. Now, also a defendant in this case, if you look at we don't want to leave him out. If you look at the lawsuit again, I wish I could have more than one document up at a time, like they let me do the videos. Let's see, where is it? All right, if you look at the lawsuit, also defendant is the ex-wife's lawyer. Oops, can't highlight that. All right, so he filed a motion to dismiss today too. And I didn't spend a whole lot of time on it, but I'll bring it up. His motion to dismiss, he's saying that he didn't get served. I'll show you his motion to dismiss. And it literally just, I saw it like an hour ago. All right, make that a little bigger. All right, so that's the lawyer's motion to dismiss. So two things. One is he's saying that the complaint, same thing, that the complaint fails to state a claim for relief, which can be granted against him since he's not a state actor. He's not a public employee. And then secondly, he's saying that he didn't get service of the complaint. So he filed an affidavit stating that he just got served with the complaint and not the summons. The summons wasn't attached to it. So he just got this complaint. Summons didn't get it. So therefore, technically, I'm not going to respond. I'm not going to respond to it at all, at least just to file a motion to dismiss. And just a quick look at the actual records shows that that's not true. Let's see. All right. He was not served a copy of the summons. And I'll show you proof that he was. All right, there is the summons that was served on him. There's the case. There's him. Signed by the clerk. Returned executed to the court by the sheriff's department process server. Served him on such and such date. Served him personally with this summons. Here it is. This officer attested that he served it on him. Returned it. It was uploaded to the court. The court ordered him to respond. So he's claiming he didn't receive it. Well, apparently he did receive it. You know, why didn't he just respond? Anyways. So yeah, the dog must have ate it. I guess the dog ate it. So the other claim is that he's not a state actor and that therefore he shouldn't have to be involved in a civil rights lawsuit because generally private parties can't violate the civil rights of others. And that is usually technically true. But one difference here is that you can, there's an exception to that. Let me look for the actual language. Looking back at the lawsuit, and this is really a detailed complaint. If you haven't looked at it, it has a lot in there. But it goes over all the specific claims. It's very, very specific. Somewhere in here is must be at the bottom. The complaint against the lawyer. Here we go. All right, conspiracy, count 6, conspiracy with a state official. All right, the defendant lost the lawyer and the defendant judge engaged in a long-term practice, agreement, relationship, and understanding where the defendant lost the lawyer possessed the ability as well as the perceived ability to request that defendant Goldston, the judge, illegally visit the homes of opposing litigants appearing before her in order to search and seize items of personal property therein. Defendant Luss would then threaten to invoke this ability during settlement negotiations with other attorneys and pro se litigants, such as my client, and he was caught on tape doing this, in order to gain an advantage. So we have a recording of him saying, back when my client had a lawyer, look, I want him to get on the stand, say he doesn't have certain things. And then the judge is going to go search his house. She's big on that, I think he said. And that's how he was going to really stick it to my client, get him in a bad position, because he knew that the judge would, if he wanted her to, would search his house and look for these items he said he didn't have. That was a year before the actual search took place. Then he called my client the night before the search took place and demanded $5,000 for it not to take place. And then when they showed up, he really didn't even have to do anything. According to the Judicial Investigation Commission, he just kind of sat there and let the judge take the reins and say, all right, we're going to your house. Be there in 10 minutes. And this isn't the first time this had happened. This was a ongoing conspiracy that spread over the course of 20 years, according to the judge, and was done in numerous cases. And I talked to a lot of different people that had this happen to them or threatened to be happen to them. And you could get out of it by writing a check. And that's what's alleged here. This relationship and agreement was demonstrated on March 4th when the judge actually searched and seized my client's house and removed items of personal property, as detailed in this lawsuit. This was performed pursuant to the private ex parte agreement between the judge and between the lawyer. And the plaintiff's only means of stopping this from happening was to pay an arbitrary and outrageous sum of $5,000, supposedly to his ex-wife, payable to her lawyer, probably. All right. Yes, he's not a state official, but he acted under color of state law by conspiring with one or more state officials to deprive the plaintiff of his federally protected rights. A private party who jointly participates in the alleged constitutional wrongdoing with a state or local official is engaged in state action. There's the citation, U.S. Supreme Court, Lugar versus Edmondson Oil Company, 1982. There's another one, Dennis versus Sparks, 1980. And then there's another U.S. Supreme Court case, 1970. They must have missed those. Defendant Lusk agreed with and engaged in a concerted action with the defendant judge to participate in this conspiracy, blah, 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 blah. You get the point. So, yes, a private party, under some circumstances, if you have strong evidence of some sort of conspiracy to violate someone's civil rights, can be held liable. And when would this ever come up? Remember the civil rights era, for instance, where, you know, it's in some of these places in the South, it could be a private business owner conspiring with the local police to keep black people out of the restaurant or to spray them with fire hoses, whatever. You're saying you can't sue the private party for violating people's civil rights? Of course you can, if there's evidence of a joint conspiracy. Absolutely. And that's very, very well established in the federal case law. So I think we've alleged more than sufficient evidence here to show that occurred. David, $5,000 in many foreign countries I lived in, this would possibly be called a bribe. Interesting. It could be called that. Have you ever heard of the court switching your court date to a prior date and then not sending notifications so you get a warrant? It happened to me 7 times. I've absolutely heard of that. Absolutely. I've heard that many, many, many times. And that's a due process issue. Tabby's daddy, what color is the law? You know what I mean. It's like traffic tickets, make a donation to the police retirement fund. Liberty not licensed, how much was going to the judge? To be clear, I have no evidence that any of the alleged $5,000 was to go to the judge, or that any other form of payment, went to the judge in any of these circumstances. We've alleged basically that this was sort of a quid pro quo arrangement that was going on only in this particular family court in West Virginia. No other family courts, where these local lawyers who had a relationship with the judge, had the knowledge or the perceived ability that they could bring the judge into a client's house or the other party's house. And then this would be used as a sword, basically, in negotiations And if you had an outside lawyer that didn't know that this was going on, they wouldn't have that same ability. And that's why we also made 14th Amendment claims. Or a pro se party is also at a detriment, doesn't have that ability. Now, is that just because they're all friends and that's the way they do things? Or is there actually some sort of quid pro quo there? For instance, campaign donations or goodwill for campaigns. I don't know other than what we've alleged, but I would expect that more information might come out in the discovery. Everything they give you everything you need to prosecute. Everything is on paper. Absolutely, it's all there on a silver platter. Mike Murphy, they should appoint me as a judge. Well, fortunately, people don't have to worry about that, because who appoints judges but the governor? And I've sued the governor 3 times, and I don't think I'm in any danger of being appointed to any judgeship by our governor. My dog Rex, that's a great point. How far will a cop go following judge's orders? Will a cop rob a bank, rape the mailman, falsely arrest, falsely imprison? Exactly. I mean, would that be a defense? The Chauvin trial is going on now. Does he have any defense? All right, the judge told me to do it. The judge told me to kneel on George Floyd's neck. I mean, no, that wouldn't be a defense if it were true to anything. It doesn't matter. If you're a sworn law enforcement officer, you know that the judge can't tell you to go hide a body, and you just have to follow orders and do it, or else, and that's a defense if you get caught. No, obviously not. And as for, at some point, hopefully, if these motions to dismiss aren't all granted, there will be testimony under oath at some point as to the details on all this stuff. Mary, thanks. I appreciate that. If you can't tell, it's Mondays are really, really busy for me. If something is going to go wrong, it's a Monday, and I'm always very tired by the end of the day. Raven, Dark Shadow, when does anyone actually get any justice on these things ever? I mean, part of the story of this case already has been, and some justice that occurred, and that was that the state disciplinary board went after this judge and got the judge to agree to sanctions, agree to admit to having violated all these judicial rules. And this really bizarre thing happened at the end, where this judicial hearing board sort of threw the whole thing out because a sitting family court judge, Judge Stotler, objected to it and felt like family court judges should have this ability. And I've written on this and I've done videos on this if you want to learn more about it. But that is just, really crazy. In the end, it's headed to the Supreme Court, the state Supreme Court, and they'll be deciding that. But absolutely not. There's no authorization for any judge, much less a family court judge, which is a court of limited jurisdiction in West Virginia, to go search anybody's house. They couldn't even issue a search warrant. They do important things, but they're supposed to do it in the courtroom, and it doesn't have anything to do with searching people's houses. They could issue a warrant awarding item, or even ordering the seizure of an item that's supposed to go to a certain person, but that's for law enforcement to execute it, or the parties. Conspiracy with individuals, federal case law resources. If you look at the complaint, it's all laid out at the complaint. So you can find all this stuff at the website at thecivilrightslawyer.com. You'll see the federal case law that I cited. I think there were 3 different U.S. Supreme Court cases on private party conspiring with a state official. And this is for purposes of civil lawsuits, Section 1983 lawsuits. So it's not criminal charges. That's not what I do. Evergreen, was that a gunshot class? Yes, it was. It was, we had a particularly rowdy day here at the office, and we took some incoming fire. Dreamland, thumbs up. I appreciate you all watching. And yes, please, why not give me thumbs up and share it and force YouTube to spread it around. Maybe they like this one because it's technically, they don't like anything that I say bad about, that which shall not be named or the governor or anything like that. But I mean, they'll let me bash on cops usually, and they'll probably spread it. And not that I'm even bashing on cops, because I've had so many cops, bring this case up to me and be like, that's just crazy. I can't believe it. And actually my client in this case, Matt Gibson, he's a federal law enforcement officer. So this is, I think this is a case that most people can agree on, I think. Now, whether or not the judicial immunity laws are going to stop us in the end, we'll find out. But, it's a fight that needs to happen, I think. Bubba, I appreciate that. Not going to happen, though. Like you guys, I have to work. Let's see. Janine, are judges supposed to know the law? Yes, they are. But they're given this judicial immunity, this absolute immunity, in case they screw something up. And I understand that, and I'm not arguing against that. No doubt people would sue judges for anything and everything that went wrong in their case. And they don't have to get everything perfect, but we have appeals that, sort of sort that out. But here, what happens if they even, according to the rules of judicial immunity, take it too far? They don't just automatically get liability anyways. They get knocked down to qualified immunity, like just a regular cop has. So that's the way it should happen. And it's sort of similar rules for prosecutors as well. And there's a lot more case law on prosecutors being sued than there are judges, because it's pretty rare that there is this sort of outside the courtroom extrajudicial behavior or encounter between, a litigant or somebody and a judge that has something to do with the fact that they're a judge. I mean, it happens, it's happened, but really nothing really like this. This is a really, really crazy situation. Let me do one more question on this before I freaking fall asleep. How are the judges held accountable? Well, there is a disciplinary process. There are strict rules, really strict rules for judges in every state, including West Virginia. And if you think they violated a rule in your case or whatever, the time limit in West Virginia is 2 years that you can file this disciplinary complaint, and you describe it, exactly what happened, and it'll be reviewed by what's called the Judicial Investigation Commission, and they can say, all right, these allegations are severe enough to where we're going to open an investigation, or they can send you a letter explaining why they're just denying it outright. And in here, they thought it warranted absolutely an investigation opening immediately. They interviewed the judge and the parties, and they proceeded with it, and they ultimately filed a formal statement of charges. I mean, there is a process, and that process was followed. So they can be held accountable. But that being said, it's disciplinary. So in the end, they're limited to really suspending the judge and taking the judge out of the seat. They can't even just do it permanently, because technically that has to be an impeachment. But you'll see, if you look at past cases of judicial misconduct, usually there's an agreement where the person steps down and agrees never to be a judge again, sort of thing. But when they fight it, all they can do is get, at worst, a suspension and a fine and a censure. And what was agreed in this case was a censure. No suspension, a censure, and then a maximum fine of, ironically, I just thought about $5,000, the same thing that was demanded of my client. But like I said, in the end, that family court judge, I think, interfered and got the Judicial Hearing Board to knock down the punishment to, instead of a censure, a written reprimand, and then lowered the fine. I don't recall to what. In the end, it's up to the West Virginia Supreme Court. I don't know what the timeline is on that, but I figured, well, we just need to proceed with our own justice while that goes on, and we'll see what happens. All right, so that's the update on family court judge case and also the new case that we filed, and we'll have more updates coming if you follow along with those. And with that being said, I had a couple other things I was going to get to, but man, I'll have to save those for Monday because it's just been, we went way over what I thought we'd go over. I mean, we have, let's see, following a little bit of what was going on with the Chauvin trial, the Capitol police officer that, if you look at the Washington Post today, came out today that, died of natural causes. So just unlike what the prosecutor said, didn't have anything to do of injuries that he suffered, quote, defending the U.S. Capitol while physically engaging with protesters. He wasn't hit with a spray or with a fire extinguisher that caused him to die. All this stuff was all just fake news. It was a completely unrelated cause of death. I guess it was a stroke the day after that this happened. There's no evidence that there were any injuries. So I kind of wanted to go into that. But if you look at the Washington Post, I think it's important to understand that. And again, that's a whole nother video that probably would get me demonetized or censored outright. So it's about that time. Let me just end with this. Look, let's defend ourselves here with freedom. And why is freedom scary? And it's because through the guise of safety, we shouldn't have to convince you of this now. Through the guise of safety, that's how we, the people, lose our liberties. Under the guise of safety, that's how we lose our freedom. Necessity is the plea for every infringement of human freedom. It's the argument of tyrants. It's the creed of slaves. That was said by William Pitt the Younger. So don't forget to subscribe for more updates, for more videos. Also, subscribe to our email updates at thecivilrightslawyer.com, where you can follow along with our pending cases and also other stuff. So I'll probably see you again on Wednesday, same time, same place at 6:30, and hit some of the other things and hit some of the non-case updates that I wanted to get to. So I'll see you then, and hopefully I'll be a little more awake.